Welcome to Part 2, Chapter 8, the hotel's right to evict a guest, tenant, restaurant patron, or others. Here again, before we get started, I feel compelled to point out that we are discussing the law on this topic as opposed to hospitality or customer service. There are clearly parts of this lecture where legal procedure and customer service will bump heads. Today we're going to discuss important distinctions and the legal procedure for evicting or removing someone from the premises. The rules regarding eviction or removal are generally covered under state law. Remember that each state has different laws in this area, so depending on where you end up working, you want to study those laws carefully. Much of what we're going to learn about today will hinge upon the proper categorization of the person or persons we're talking about. The four important categories are guest, tenant, patron, and, for lack of a better term, persons other than guests. As you'll see later, for North Carolina law, we will have to add a few more categories. These categories are important to understand because in each instance where we want to remove them from the premises, the rules are going to be dramatically different. The first distinction we'll talk about is that between guest and tenant. In the last chapter, I used the analogy of renting an apartment or a home as a way to illustrate the privacy right that a hotel guest gains during their stay at the hotel. While there are similarities in the two situations, when it comes to evictions, those similarities end abruptly. This distinction is important because the process of evicting a guest from a hotel is infinitely easier than the sometimes long and expensive process of evicting a tenant using the court system. Hotel guests are not usually considered tenants because of the transient nature of their stay. However, the mere fact that an establishment is called a hotel is not always dispositive of the distinction between guest and tenant. The decision is based on the nature of the relationship between the establishment and the person, the length of the stay, as well as any contract and applicable governing law. Consider extended stay hotels with efficiency type apartments or renting a house or condo at the beach as examples where the distinction may be blurred. North Carolina has done its best to make our jobs a little more clear and to remove doubts that might otherwise blur the line between guest and tenant. Let's take another look at the North Carolina General Statute regarding inns, hotels, and restaurants in your additional materials. Section 72-1B indicates that, as far as hotels are concerned, as long as we have the guest sign a form or statement setting forth the time period in which they can stay in an assigned room, we have a valid contract, and at the end of that contract, quote, the lodger may be restrained from entering. This is otherwise known as locking out and is tantamount to an eviction of the guest. Nice to see our knowledge of contract law being put to use there again, isn't it? Likewise, the North Carolina legislature has considered the condo at the beach problem we mentioned earlier by enacting the Vacation Rental Act, which I've included in your additional materials. This law creates an additional category between guest and tenant, which we will call vacation renter. The Vacation Rental Act requires that agreements with vacation renters be in writing, and among other things, in Article 4 it provides for expedited eviction proceedings. If you're wondering why something like this act is necessary, take a look at the video in your additional materials titled Airbnb Guest Won't Leave. In that video, you will see the difficult process required if we need to evict someone who falls into the next category of tenant. The bottom line there is, when someone is considered a tenant, we will need to make a trip or two to the courthouse to go through a more formal eviction proceeding in front of the magistrate or judge. The final two categories are patron and persons other than guests. When we use the term patron in a legal sense, we're usually talking about someone in a restaurant or bar as opposed to a guest staying at the hotel. And persons other than guests are visitors to our hotel that may just be looking around. They might be shopping or possibly visiting a registered guest. These last two categories don't normally require any formal process and can be removed from the property for just about any valid and legal reason. So now that we understand the categories and a little bit about how each category is evicted or removed, let's take a look at the reasons we can rightfully evict or remove. I'll point out up front that I am not going to go through the reasons we can rightfully evict someone who falls into the category of a tenant. I'll just say this: if you think someone is a tenant and you're not intimately familiar with your local eviction laws and processes, I would strongly recommend that you consult with an attorney. With regards to the category of guests, hotel management can evict or lock out for any of the following reasons. 1. A violation of a reasonable and non-discriminatory hotel policy or rule. These policies can include rules that keep guests safe, like no hanging over balconies, swimming without a lifeguard, etc. Rules that prescribe offensive behavior, like public drunkenness or the proper attire, being fully clothed, or any form of willful misconduct, like damaging hotel property. 2. Non-payment or overstaying. If a guest fails to pay a bill or stays longer than their reservation, they may be properly evicted. Interestingly, a guest may be evicted because of illness with a contagious disease. You may recall the discussion we had in an earlier chapter about our duty to keep all of our guests safe. This eviction definitely falls into that category, but must be dealt with in a way that takes into account the delicate nature of the situation for the guest who is sick, as well as those whom you are trying to protect. When dealing with patrons, we can add to the above list the refusal to pay for food or other service. The legal threshold for removing patrons is a bit lower, and obviously no written contract is required. Finally, the category of persons other than guests. If a person is not a paying customer, is just visiting the lobby or a guest in the hotel, the rules are somewhat more flexible. Generally speaking, and again from a purely legal standpoint, persons other than guests may not enter or remain upon the hotel's premises against the proprietor's will. We usually deal with a situation when an event, an area, or a property is reserved for guests, or if the person has forfeited the privilege of remaining on the premises based on their conduct. So that wraps up our discussion for Chapter 8, as well as our general review of Part 2. We've explored a myriad of topics surrounding the hotel-guest relationship using both state and federal law, as well as statutory and common law, and touching quite a bit on contract law. I hope you found these videos as well as the additional materials helpful, but I don't want you to hesitate to contact me if you have questions. Take care and have a great day.